What's up, Inquirers? In today's video, we're going to be talking about the arraignment for Gregory McMichael, Travis McMichael, and William Roddy Bryan, the motions filed by Kevin Goff on behalf of Mr. Bryan, and the third investigation that's been opened up into Mr. Bryan stemming from the shooting of Ahmaud Arbery. If you haven't already, subscribe to this channel. You are watching Inspiring Inquiry. Okay, so we're going to basically go through the arraignment procedure, and we're going to talk about some of the arguments made. We're going to talk about the motions that Kevin Goff is bringing up. We're going to talk about the prosecution's arguments against those motions, against the admittance of evidence. And so we're going to try and stay on track as much as we can and explain what exactly is going on as we go along. So these procedures are being presided over by a judge, Timothy Walmsley. So as it starts, the judge talks to Gregory and Travis McMichael, assures that they can hear everything. He talks to their counsel, assures that. They move past that, and they move straight to whether or not they're going to plead guilty or non-guilty. And they both plead not guilty. After that, the judge goes on to say how they go off of a scheduling system. So they're going to have everything scheduled in the way that they're going to be addressing this in the courtroom. Basically, just to keep things orderly and timely with regards to this case. After that, they do some shuffling. Gregory and Travis McMichael go away. They bring Roddy Bryan in. So immediately out of the gate, Goff starts doing some of the things that he was doing in the preliminary hearing. He starts bitching and complaining about some of these things. They are related to masks, and I'm actually going to cover them in another video so that it doesn't bog this video down. So just be on the lookout for that. The judge says that he isn't going to be swayed by anyone's mask, and he wants to basically stay focused on the business at hand. Mr. Evans, the prosecutor for the state, goes over the 9 charges being listed here today. Count 1 being malice murder, counts 2 through 5 being varying counts of felony murder, counts 6 and 7 being aggravated assault, count 8 being false imprisonment, and count 9 being criminal intent to commit false imprisonment. Now, at this time, Goff also waives his right to a formal reading of the charges in the indictment and enters a plea of not guilty, but also wants to note that he has a number of different motions that need to be addressed by the court, or the judge actually has to decide whether or not these motions are going to be addressed by this court. See, the point of this arraignment is just to enter a plea of guilty or not guilty. Mr. Goff, just like in the preliminary hearing, wants to enter in a number of other things because he is under the assumption that his client shouldn't even be here in the first place. The court enters that not guilty plea, and then the judge remarks on the fact that in this COVID-19 era, there are going to be a number of delays and things that are going to be different. Normally, they would go ahead and announce the trial docket date, but in this case, they're not going to go ahead and announce it because they're not too sure of how things are going to proceed from this point on. So that will be announced at a later date. Now, after the judge makes that statement, Goff wants to discuss his client's right to a speedy trial and note that he does not consent to a COVID-related delay. The judge assures Mr. Goff and his client that he wants things to move along just as much as they do. Now it turns to Mr. Evans, the prosecutor, and he says that morning around 8 or 8:30 that his office received a number of motions that were being filed, and that given the scope of the arraignment hearing, that it's only meant to address specific things, that he doesn't think that all of these motions should be addressed by this court today. The judge gives the remarks that he doesn't normally notice hearings like the way that he is in this case, that he doesn't really like surprises. He likes to know exactly where they are and where they are going, and that he isn't actually even sure if some of these motions that have been filed that morning are to be addressed by this court. Goff simply states that he wasn't expecting to address every single motion here today. The judge notes that there are some motions that are going to be addressed at today's hearings. One of them being the motion to strike the appointment of Joyette Holmes as the district attorney. But before he even gets to that, he wants to get to another motion that was filed, relief from prejudicial or inflammatory statements made by individuals purporting to speak for the victim and his family, and for other relief. The court entered an order granting the intervention and actually notes that there weren't any objections by the state. Now, Mr. Evans comments on this and says that it's essentially a gag order, but Mr. Goff says that his main concern is that certain details that aren't public knowledge will be released to the victim's family or the representatives of the victim's family, and he wanted to make sure that that wasn't going to be done. Mr. Evans and Mr. Goff had already come to the agreement that if Mr. Evans got up in the court and says that, his office has never done that before and they don't intend on starting now, that Mr. Goff would go ahead and drop that motion and abandon it, unless, this does come up again, in which he will be refiling the motion and it'll be addressed at a later date. So they take a short recess, but once they come back, they start discussing the appointment of Joyette Holmes as the district attorney. All right, so even though this is one motion, it's kind of like a three-parter. One of them being the recusal of Tom Durden as the district attorney. Basically, what Kevin Goff's argument is that district attorneys can only recuse themselves for two reasons, one being interests and the other being a relationship. He basically argues that DAs don't get to choose which cases they try and which ones they don't, and that as a point of Georgia law, that it is Tom Durden that should be pursuing this case. The second part of this motion is that once Tom Durden recused himself, that the Attorney General's office was the one who appointed the new district attorney. Goff argues that the Attorney General doesn't have the authority to appoint a new district attorney in this case, and notes that historically it is actually the courts that are the ones who appoint a new district attorney once one recuses themselves. And the third part being that when a DA recuses himself and a new one is appointed, that paperwork needs to be filed within a timely manner. Apparently that was taken place on May 11th, and the paperwork wasn't filed until June 8th. And so he kind of makes the claim that there was a secret prosecutor being appointed to the case. The judge goes over the letter from Tom Durden and says that in it, he states where he doesn't have the resources, and he doesn't see how that isn't a conflict of interest on the part of Tom Durden. Then notes that the state has referenced the case, the State versus Mantooth, because it bears some relevance on what actually is going on here. In the case State versus Mantooth, they actually ruled that the court doesn't have the authority to challenge the appointment of a new Solicitor General by a district attorney. But Goff also noting that most counties don't actually have a Solicitor General, so it's not really applicable to here. On behalf of the state, instead of Jesse Evans handling this portion, he turns it over to a Miss Linda Dunikowski. In response to this motion, Mrs. Dunikowski actually argues that this is an attack on the Attorney General's office, it is an attack on the statute itself, and that it's basically just wordplay. And she asserts that the word that Mr. Goff is playing with here is the word interest. Now, interest can be taken, a number of different ways. Now, what he's saying is that, Tom Durden didn't actually have an interest in the case itself. But Ms. Dunikowski is going to make the argument that Tom Durden has a responsibility to the Atlantic Judicial Circuit. Now, having that responsibility is an interest of his. And whenever he realized how big this case was getting and how much resources that it was going to take and how much time it was going to take, he decided that it was better to hand this off to someone else, someone more capable of handling this type of case, because it would have taken him away from some of his other responsibilities and not left him in a position to do an adequate job of performing his duties. She also argued that to get him to come up there and sit on the stand, that he would actually be breaching a client-attorney privilege by doing so. And if he was to get up there and talk about the reasons why he left the case, that he would actually be in breach of that. She ends with saying that essentially what Mr. Goff and his client are trying to do is choose their prosecutor, and that there is no law or statute that gives any person the right to choose their prosecutor. Now, with regards to the way that things were filed and the time scale that they were on, Ms. Dunikowski actually gets up and says that yes, she messed up. She didn't file things as quickly as she probably could have. That at the time they were having a e-filing issue, and that she didn't actually have a way to file electronically these things into the case. But she said, regardless of that, the reason that you would file these things is so the defense and other people are alerted to the change that's taking place. She said that Mr. Goff was alerted to this prior to that. Lastly, noting again in the case of the State versus Mantooth that the court ruled that it didn't have the authority to challenge the appointment of a district attorney by the Attorney General. So Kevin Goff comes back and says that this whole e-filing story is just utter nonsense. He said that it wasn't true. He said that on the day of the preliminary hearing, she was there all day and she could have been there. She could have filed it. And actually 2 days prior to the preliminary hearing, there was a notice issued to their office saying that they weren't sure basically about the appointment and everything like that, so that she should have had it filed by the time that he thinks that she should have had it filed. Given all the factors that were going on with this, the late e-filing and the question as to whether or not the statute covers this kind of appointment and whether or not he actually had a grounds for recusing himself, he requests a hearing to decide whether or not this is something that needs to be addressed. After hearing both of their arguments, the judge gives a number of reasons as to how he's going to rule upon this. One of them being he doesn't believe the court in this setting has the authority to address that. 2 being he doesn't see an issue with how the Attorney General was notified. 3, he doesn't see that Tom Durden didn't comply with the rules when he wrote the letter. And 4, he didn't hear an argument either in the motion or from Kevin Goff himself to prejudice or surprise. He says that the ruling of his court is that a full-blown evidentiary hearing is not necessary, and therefore he denies the motion. And thirdly, the next motion that we turn to is the amended motion for bond. Now, essentially at this point, Goff wants to tender a number of exhibits that may influence the decision on the bond. Jesse Evans gets up because he's going to be handling this part of the procedure from here on out, and he says that there are a number of exhibits that Mr. Goff is trying to get tendered into evidence that just aren't relevant to the hearing that they're having there today. Now, the judge says that he was under the impression that they were kind of in an agreement as to what exhibits were going to be entered and which ones weren't going to. Since they kind of have that disagreement, what he does is he recesses for a few minutes, allows them to talk, and then they end up coming back. They kind of go back and forth as to whether or not they want to go over each one specifically to decide whether or not they're going to admit it into evidence, because that could be a lengthy procedure. You know, Goff says that it could take an hour, hour and a half, but since they kind of discussed it, they really just only need to talk about the 3 exhibits that the state is objecting to and decide whether or not those can be admitted into evidence at this point. So they agree on 1 through 6, 6A, and 7 in the exhibits. The other ones that they don't agree on is Composite D3, which is a collection of videos that are related to the case, and exhibits 14 and 15, which are prior convictions for the victim Ahmaud Arbery. Jesse Evans states that he is objecting to the character evidence just like he did in the preliminary hearing, that he is used to these preliminary hearings and bond hearings and things to go a particular way. He thought that this bond hearing was going to be like most bond hearings where they follow a particular procedure. Goff says that he kind of wants to move the proceedings along. He just kind of wants to go over the 3 that they disagree with. He has a witness that wants to come up and give some words. He said it'll take about 5 minutes. He said that the state has let him know that they also have a witness that wants to come and speak and that should take about 5 minutes. So he kind of wants to move along and wrap things up, and he's not trying to drag these things out by going over 1 through 7 of the evidence that's being admitted. He just kind of wants to agree with it, submit it to the judge to see whether or not they are going to admit that into evidence. Evans objects to the introduction of Composite 5 because he says that it isn't relevant to the bond hearing, and that Goff said that it's to address the strengths and weaknesses of the case, which also have no bearing on a bond hearing. Goff cites some statutes and some court decisions in which these things were relevant in other court cases, and he basically is just saying that he wants to leave it up to the court to decide whether or not they think it is relevant. Whether or not his client is likely to be convicted of the crime, he wants the judge to take that into consideration when deciding whether or not he's going to give him a bond. The judge apparently hasn't seen the videos, and he just asks what are the videos of. Now, he says that he doesn't want to hear an editorial of what's on the videos. Like, he doesn't want him to explain, frame by frame what's going on. He just kind of wants to know what these videos are about and why they should be admitted into evidence. Goff explains that it's the videos that were taken of Ahmaud Arbery outside of the English home, the videos that were taken of Ahmaud Arbery inside of the English home, as well as the video of the shooting itself. He said the videos and the testimony of Agent Richard Dial don't actually track with one another, and he wants to get it on file just in case they end up appealing this at some later point. The judge says that he's going to go ahead and admit it, but not because he thinks that the strength of the case is actually a determining factor in deciding bond, but that there are a number of evidentiary exhibits that he hasn't had a chance to go over yet. So with that explanation in mind, he is going to go ahead and admit it into evidence, but that he really wants to focus on the 4 factors being considered in a bond hearing. Later, we're going to go over what those 4 factors are. Now, the reason for this next exhibit just blows my mind, but I shouldn't be surprised at this point because of the way that Kevin Goff tries to argue. So the next exhibit are the 2 prior convictions for Ahmaud Arbery that show that he was actually on probation at the time. The reason that he wants these into evidence is because he is going to argue that given the state of mind that Ahmaud Arbery was in, being on probation and just coming from a house, that Ahmaud Arbery should have been subject to a citizen's arrest by those 2. Like I said, it just blows my mind. He is basically arguing that Travis McMichael and Greg McMichael were unlawful, but that because Ahmaud Arbery didn't know that and that he knew that he was on probation, that he should have just let himself be citizens arrested anyway. He should have let them violate his rights as a human being. Now, although I haven't mentioned it up until this point, the judge has had to clarify many times that this court, these proceedings right here, which are about a bond hearing, will not be used as a vehicle to try this case. He has been trying to give reasons for their actions, which is an argument for what was going on. In the preliminary hearing, it was just to decide whether or not there was enough to charge the men with those crimes. He's already trying to skip past that. He was trying to skip past the arraignment. He was trying to go right to the trial and say, nope, we should get it thrown out because my client never should have been here in the first place. That is the my cousin Vinny defense.
It appears to me that you want to skip the arraignment process, go directly to trial, skip that, and get a dismissal.
Now we hear from Jesse Evans. Evans objects based on relevance with regards to the 4 factors being considered in this bond hearing. Now, despite the judge once again saying that this court will not be a vehicle for trying this case, Goff once again tries to argue that if Travis McMichael's actions on that day were lawful in defending himself against Ahmaud Arbery, that there is just no case for his client. He's trying to basically argue on the behalf of Travis McMichael, saying that he was lawful in his actions, and so therefore, because he was lawful in his actions, his client actually shouldn't be charged with anything. Because remember, Ahmaud Arbery knew he was on probation. He knew he had just come from a house. So he should have let those men violate his rights because he knew about all these things. Upon hearing this argument again, Evans immediately stands up and objects. And the judge straight up looks at Mr. Goff and asks him, how do you know that? Goff says because there's video of him being in the house and coming out of the house that Ahmaud Arbery knew that. And so the judge just stops him right there and says that he's going to go ahead and sustain the objection. At this point, the defense calls Preston Roderick Kelly Bryan to the stand. Now, this is William Roddy Bryan's son, and he's basically going to come and answer a number of questions that Goff and the prosecutor is going to ask him with regards to his father and how he would behave or how he would adhere if he was given a bond, and whether or not he would pose any risks based on the 4 factors being considered for bond. Those being the risk of flight, the risk of danger to a person or property, the risk of committing another felony, or the risk of intimidating witnesses. Those are the 4 factors being considered in a bond hearing. That is all that the judge and the prosecution wants to focus on as to whether or not how they would rule on a bond. And Mr. Goff wants to throw in a number of other things like the strength of the case, and he wants to give argument as to the actions of Travis McMichael. But I'm getting off track a little bit there. So basically now he asks him those questions, and he asks, if your father was granted a bond, would he comply with the orders given in that bond? His son, of course, says yes. Mr. Goff notes that he lost his home and he lost his vehicle and he lost his job ever since these things took place. But then he asks his son whether or not his father would be able to retain employment while he was out, and whether or not he would have family or someone to stay with while he was out on bond. His son replying yes to both of those things, that he would have family to stay with, and that he knew of jobs that his dad could get if he was to get out. Now it being Evan's turn, he gets up and asks him a line of questioning based on the same thing, the 4 factors taken into consideration as to whether or not someone should get a bond. So he asks him about Roddy Bryan's ex-wife, who lives in Costa Rica, and whether or not they had been in communication with each other. The son agrees that he does have an ex-wife, that she does live in Costa Rica, that they had gone to visit her before, but that the son himself hasn't been in contact with her in quite some time. Apparently they got a divorce and she's been remarried. Evans asks him, since he lost his home and his vehicle and his job, whether or not he had anything of worth that he would be able to put up for collateral to be able to attain that bond. And his son says that to his knowledge, he doesn't know of any properties or anything, but that he has family that would be willing to help him out in that case. He asks him if he has family nearby, and the son says yes. Then he asks him whether or not he has friends or family outside of the state, and the son says that he doesn't know, he doesn't think so. He asks him if he did get bonded, what job that he has waiting on him, the son replies that he has 2 places that would probably give him a job if he was to come out. Evans notes for the court that it was a probably and not a definitive answer. Turning back to Goff, he gets up and he asks him whether or not he had friends and family that would be able to help him. The son says yes. He asks him whether or not his father speaks any other languages, mainly Spanish, and whether or not it would be reasonable for him to go and try and live somewhere else. The son says no, he doesn't speak any languages, he doesn't speak Spanish, and he doesn't think that it would be reasonable for him to, flee and go live somewhere else. Goff asks him if he was fitted with an ankle monitor, does he think that his father would comply? The son says yes. Now he also says if he wasn't to comply and he was trying to thwart that device somehow, would his son report him if he was to do that? The son said that yes, that he would report his father if that was to take place, and if he was to do anything that he wasn't supposed to do, that there were other people like friends and family that he might be staying with that would also turn to the police and report him if those things were in fact carried out. Now it shoots back over to Evans. He was asking him if he was to come out because his son was saying that he would be able to report on him, whether or not his dad would actually live with the son. The son said no, that he wouldn't be living with him, but like I said before, if he had to, he could. After noting all those things, the judge excuses Preston Bryan from the witness stand and they move on from there. Evans addresses the evidence before the court, and he says in addition to the 7 that they agreed upon, he also wants to enter 2 statements from the parents of the victim, Ahmaud Arbery, one being an address from the father, a victim impact statement, as well as an address from the mother, another victim impact statement. We're going to go ahead and play the clips of those 2 giving their statements for you guys right now.
This is from Ahmaud's father. I suffered the deepest loss a family can endure. When the McMichaels, with the knowing participation of William Roddy Bryan Jr., acted as my son's judge, jury, and executioner, I urge the court to reject the motion for bond and continue to keep Mr. Bryan behind bars and to maintain District Attorney Joyette Holmes as the prosecutor on the case. That's his short statement that he asked that be shared with the court. Would you please share that with the court?
Thank you. William Roddy Bryan conspired with 2 other men to kill my youngest son. I named him Ahmaud Arbery. I raised Ahmaud on my own in the small community of Brunswick. Ahmaud was loving. Ahmaud worked extremely hard to provide income for our household. Also, Ahmaud also worked hard to be physically fit. Mr. Bryan does not deny getting into his pickup truck and chasing my son. He does not deny blocking his pathway. He does not deny recording the murder of my son. He does not deny being within feet of his co-conspirators as my son was called a racist name as he laid on the ground before passing away. He does not think there's anything wrong with what he did. He wants this court to allow him to go home. I am asking this court to say no. He cannot go home. He did not allow my son to go home. My son ran away. My son actually ran around him, and my son actually ran for his life. But William Bryan did not allow my son to return home. So I stand before you as the mother of Ahmaud, asking this court to give Mr. Bryan the same energy that he gave my son. There is not enough evidence to establish this unrepentant man in being a danger to this community. He lived just feet from where my son was murdered. I lived just miles away from where my son was murdered. I'm actually scared, Judge, to stay inside of my home. I've actually put my house up for sale. often visit the location where my son was killed. And each time I visit there, I fear running into either three of the men that murdered my son. Because William Bryan does not feel he did anything wrong, what is it to say to stop him from doing this again? He must remain in custody. He's dangerous, he's unapologetic, and therefore I'm asking this court to keep him behind bars.
Now, after Jesse Evans read off the statement given by Ahmaud Arbery's father, they had Ahmaud Arbery's mother come up there. Now, before she actually gave her statement, they kind of had a little quibble about whether or not she should be sworn in. Kevin Goff wanted to say that whenever she gave her victim impact statement, that if she was to be sworn in, that she would be subject to cross-examination. This kind of caused a little confusion between the prosecutor and the judge because they were just trying to ascertain why he would want to cross-examine her based on a victim impact statement. To clarify, a victim impact statement isn't actually a statement that is going to be like on the record as the court's going to be referencing it as a fact. It is basically just the parents saying this is how they feel, this is how they've been impacted as victims by what's going on. It's not a sworn statement or a testimony or anything like that. So Kevin Goff says if it helps move the proceedings along, that he'll waive that right. But note this because later he basically changes his mind. Goff gets up and addresses the court to say that the prosecution has not provided sufficient evidence to show that his client is actually a risk for any of the four factors being considered in this bond hearing. Then he starts to go on to cite some other cases and how they've ruled in those, and he gets a prompt objection from Jesse Evans as he stands up and says that it isn't relevant, how other cases have been ruled on, that we're here to discuss the case of William Roddy Bryan in regards to the shooting of Ahmaud Arbery and whether or not there's enough evidence in this case to pose him as a risk. A judge sustains this objection, and Goff gets back up and basically starts down the same line of argument again, garnering another objection from the prosecution. The judge is claiming that he has already ruled on this and that they will not be discussing the rulings on other cases, that they are here to discuss this case. Goff starts again with the "my client is too stupid to know that he was committing a crime" defense, as well as saying that he wasn't aware that the McMichaels were committing anything unlawful. He says that it is absurd to think that there is a lynch mob running around Satilla Shores in 2020. He says, I quote, "It didn't happen." Now, even though Kevin Goff waived his right to cross-examination, he now says that he wants to address the claims made in the mother's victim impact statement. And here's a little bit of that exchange.
I understand the argument. Again, we're not trying the case here today. I understand that there are defenses that will be raised.
I do specifically want to address issues raised by the mother of Mr. Arbery. I think I'm entitled to do that.
Well, it's unsworn testimony. That's a victim impact statement.
But if the court considers it, I can...
You need to let me finish. I'll give you all sorts of opportunities to talk. Give me an opportunity to talk. It's a victim impact statement. It's not being considered by the court as evidence. It was unsworn. It's simply the mother of the victim stating her position on bond.
Thank you. And directing Your Honor to the preliminary hearing transcript that's been admitted in evidence and Exhibit 3, the videos in this case. We respectfully submit that the narrative that has been put forth at times has been correct. It has been suggested that Mr. Arbery was simply jogging while black.
We're not getting into that. Again.
After that, the judge goes on about how long the preliminary hearing was and how much cross-examination there was. He says that that was one of the longest preliminary hearings that he's ever seen, that there has been a lot of evidence already introduced into this case, and that he has to go over a lot of this evidence. And almost as a last-ditch effort, Kevin Goff starts to argue for the granting of a bond based on COVID-19 related problems. Now it's Evans' turn to argue against it, mainly that the defendant is not entitled to a bond as a right, that the proceedings were filed within a reasonable and timely manner within 90 days, and then cites where it's codified that if it had exceeded 90 days, that there are certain circumstances in which someone may be entitled to a bond, but those are only under certain circumstances, not all circumstances. Now, Mr. Evans goes on to cite a number of different evidence that supports his reasoning for thinking that he does pose a risk to the four factors being considered, and notes that the failure to meet one of those will result in the denial of a bond. He gives evidence to show that he met the criteria of filing it within 90 days. He says that he's glad that the court has already read the transcript from the preliminary hearing and references it, saying that the defendant and the co-defendant saw the victim, said, "You got him." Then they chased the victim for several minutes, saying that the defense noted that he didn't have a firearm on the day of the incident, but along with evidence provided by the investigators that William Roddy Bryan in fact used his truck as a weapon. And according to Roddy Bryan's own statement, that he didn't even know the McMichaels that well and still chose to engage in those acts against Ahmaud Arbery with the McMichaels. They had communication after the shooting, but before the arrest. Also that Gregory McMichael referred to William Roddy Bryan as an ally in the transcripts from the jail. He cites the civil rights investigation regarding the federal charges that are being considered, and he notes that Exhibit 7 is particularly telling because it's a list of the text messages containing racial slurs from William Roddy Bryan. Certain racial remarks such as the N-word, calling people a bootlicker, talking about monkey cages, and even referring to working like an N-word. It's a particular note in light of the fact that other charges are being considered, that Mr. Roddy Bryan is a particular flight risk because the sentencing that he's facing could be life plus 27.5 years. Then, as I stated in the intro, Mr. Evans drops a staggering piece of information in that the GBI has also opened up a parallel investigation into Mr. Roddy Bryan stemming from the text messages based on sexual crimes. Now, he says that he has already discussed this with Mr. Goff and that he had received confirmation in an email that morning, now providing direct evidence for the 4 factors being considered. As far as a flight risk, he is very concerned with the relationship with a person in Costa Rica, his ex-wife, because just days before the shooting, they have evidence of text messages and communications between the two. As to whether or not he would be a danger to persons or property, he wants to remind the court that William Roddy Bryan used his truck as a weapon to corral an unarmed man. Now, with regards to committing another felony, Prosecutor Evans actually admits that he has a very limited criminal history, but that he's definitely started it out with a bang. Finally, he addresses the concerns about COVID-19, saying that he is very confident that the sheriff of the Glynn County Jail is good enough at his job to be able to provide a safe living environment, and actually says that it may even be a good argument that this is a safer place to be than out amongst everyone else, out working and doing other things. Then he basically summarizes the arguments for the reasons why William Roddy Bryan isn't deserving of a bond. Mainly that bond is discretionary, the defendant is not entitled to a bond, and for those reasons they ask that they deny bond. Lastly, shooting back over to Mr. Goff, he says that they aren't even going to begin to address the charges being filed by the Department of Justice, that whenever, if and when that ever comes up, that they will address it then, and that the court can always decide to go ahead and allow bond and then revoke it at a later date, given whether or not they actually do file any charges against him. He says that it is unimaginable to think that in this COVID-19 environment that his client would be fleeing to any other countries, regardless of whether or not it's Costa Rica or not, given the passport situation, given the state of travel between the United States and other places, that these things just aren't likely to happen. And even though Mr. Evans didn't specifically talk about intimidating a witness, Goff still argues against it anyway and says that this isn't that case, that he isn't some mob mastermind who's going to be out there intimidating witnesses, that in fact William Roddy Bryan is the only witness in this case. For those reasons, he believes that the court should grant William Roddy Bryan a bond. Now, going back to the evidence, the judge says that there are a number of things that he just isn't familiar with. So before they move forward, he wants to go ahead and take a lunch. And he says that he's confident on their lunch break that he will be able to go over that evidence that he hasn't seen and determine whether or not it is going to be applicable to this hearing. Once they return, the judge says that the court is ready to rule on the amended motion for bond. Here's a short clip of the court's decision.
Order of the court is that bond is denied. The basis of the bond is the risk of flight primarily. Life without plus 27 years is a significant sentence. They understand there are at least 2 ongoing investigations of this defendant, including potential hate crime charges from the federal government and some additional investigation by the GBI. The contacts in this state really could cut both ways, but because of that, the court does have concerns with the defendant's current unemployment, lack of real property, and other issues in the state of Georgia. There are a number of other factors the court has considered. I'll make sure that those are reflected in a written order so that both parties have an opportunity to review that and understand the court's full decision. That being the order of the court.
All right, guys, I appreciate you watching my video. As always, this was a lot of fun to critique and kind of go over and talk about some of the law and some of the arguments that are going on with the case. We are going to be covering this and following it for a while, you know, to see whether or not new things come out, when the trial docket is going to be announced, and when we can look forward to the next video on that. If you haven't already, like this video, share this video if you want other people to see it, subscribe to this channel, make sure to hit the bell notification so you can be alerted when new videos come out. As always, you guys are watching Inspiring Inquiry.